Good afternoon. My name is Catherine Curtis. I am the secretary for the Rio Grande Valley Bankruptcy Bar Association, and I am pleased to be here today for one of our first podcast recordings with Marc Myers, who is a shareholder at Ross Banks in Houston, Texas, and he's an experienced bankruptcy practitioner who focuses his practice on representing trustees in bankruptcy. And what we're going to be talking about today are sales in bankruptcy under 363 of the Bankruptcy Code. This podcast is not just for bankruptcy attorneys. I think it could be useful for real estate professionals. We have real estate professionals on the line today, and as well as escrow agents, underwriters, anybody who wants to know a little bit more about the sale process in a bankruptcy case. So without further ado, I'm going to turn it over to Marc. And I'm going to start out, Marc, with asking you to please explain just generally what a 363 sale in bankruptcy is.
Thank you for the opportunity to do this today, Ms. Curtis. Hopefully this will be informative for all the persons who are going to be listening. A 363 sale refers to the provision of the Bankruptcy Code, 11 U.S.C. 363. And that is the provision of the Bankruptcy Code that deals with the sales of property, be it real property or otherwise, either by a Chapter 7 debtor, a Chapter 7 trustee, a Chapter 11 trustee, or perhaps a debtor in possession in a Chapter 11 case, or even in certain circumstances, maybe even a Chapter 13 debtor. But that would be a little bit more unusual. A 363 enables the sale of that type of property, any type of property, basically. Further, 363 is extraordinary in that it's, in certain circumstances, allows for the sale of whatever is being sold free and clear of liens and claims and encumbrances, so that the party that's purchasing the property being sold gets literally pristine title to that property. There's really no better way to get clean title under law than a 363 sale in a bankruptcy case. Now, the liens and claims and encumbrances that formerly attached to the property being sold attach then to the proceeds of the sale. And that can occur when there's a dispute, say, over debt, where there's a dispute over ownership, where there is sufficient funds from the property to be sold to pay all creditors in full. It is a very useful tool for the party selling something in a bankruptcy case to sell property where there is some dispute or something that might otherwise frustrate or delay an ordinary sale outside of the bankruptcy world context.
So, Marc, one thing I want to ask you is, if you go through the process of trying to sell a property, you may have certain abstract of judgments or other things that would show up on title report. Sorry, I don't know what that sound is. I'm not sure what that is. But if you have an abstract of judgment or something show up on a title report, what does that mean in terms of a 363 sale? Does that mean the sale can still go through and the bankruptcy estate is going to then be responsible for paying liens with the funds it gets in?
In a general sense, in the most common circumstance where you're selling a piece of property subject to a bankruptcy case, you're selling it where the party selling the property expects to get equity or funds over the debt owed as a result of the sale. And in that instance, it is common to use 363F, which is the free and clear provision, to sell the property so as to give the buyer sufficient comfort that they're getting free and clear title. Although if you're getting paid in full, it's not necessarily required that you pursue the sale under 363F. You could just do a normal sale in 363B. However, and for my trustee clients, I always suggest utilization of the free and clear language of 363. In terms of a situation where perhaps there's a judgment lien that exceeds the sale value of the property, That doesn't necessarily mean that you can't do the sale. Um, Although the code requires that a secured creditor get paid in full, otherwise it's capable of objecting to the sale. Um, a secured creditor is truly only secured if it's secured. If the property to be sold is not worth what the lien amount is, it's possible, depending on the discretion of the court and the evidence presented to the court in support of the motion to sell the property, that even an over encumbered piece of property could be sold. However, that's a bit more rare than where you're attempting to recover equity. Another common scenario is where you've got the secured claims exceeding the value of the property, but for some reason the secured creditor is willing to consent to that sale and allow it to go through. Perhaps it's cleaning up a legal title issue for them, or a legal dispute, or it resolves some problem for them as a result of the sale. In those instances, obviously a bankruptcy estate is not going to engage in that kind of sale for no compensation at all, since it's typically the obligation of a trustee or a debtor in possession to act in the fiduciary interests of the creditors in the case. It's common that in those situations that there'll be a surcharge, which means that the secured creditor is willing to give up a cut of what it's supposed to get to the bankruptcy estate so as to facilitate that sale.
Okay, so I guess getting to a more basic question, who is the seller in a bankruptcy case? Would it be a trustee or the record property owner?
It depends on the type of a bankruptcy case you have. If it's a Chapter 13 or Chapter 11, it is the debtor in that bankruptcy case who's selling the property. Much more commonly in the Chapter 7 case, where it's a total liquidation, a Chapter 7 trustee is appointed to oversee the administration of the bankruptcy estate. And by operation of law, when a Chapter 7 debtor seeks Chapter 7 relief, all its property, unless otherwise exempt under law, becomes property of that bankruptcy estate and is subject to control by that bankruptcy trustee. So in that instance, the trustee or the bankruptcy estate will be the seller of the real property, since the bankruptcy estate is the owner of the property, and the trustee acts on behalf of that estate. So it's normally the name of the trustee is listed on the owner's contract and all the closing documents.
What types of contracts can a realtor, real estate professional expect with a trustee in bankruptcy or a debtor in possession acting on behalf of a bankruptcy estate that's trying to sell some property?
Well, at the beginning of the sales process, obviously, just like in any normal non-bankruptcy transaction, you'll have some form of a listing agreement, giving that broker the exclusive right to list the property to be sold for a period of time. And then on the back end of it, you've got earnest money contracts as well, but we'll talk about that in a second. In terms of the listing agreement, it's going to be an agreement as between the Chapter 7 trustee and the state and the broker. It is in Texas, the TREC form for listing agreements are used, whether it's single family or whatever. It's always almost always the TREC form. Now, the broker involved in that can reasonably expect there to be some form of modification or interlineation of the standard form that the TREC promulgates because of the fact that you're in a bankruptcy case. Trustees are not your regular seller. They have restrictions and realities that prevent them from doing certain things that a normal seller might otherwise do or be able to agree to. An example of this is most of the TREC form contracts, whether in the listing end or the selling end, will have some form of indemnity language or representations as to status of the property. Indemnifications by a bankruptcy trustee are extremely problematic. If for no other reason, bankruptcy estates have a limited lifespan. They have a beginning and they have an end. And the only point in time where there are assets out of which to be indemnified during that lifespan is while it's alive. After a bankruptcy case is closed, by virtue of the bankruptcy process, all money taken into the bankruptcy estate is dispersed out to creditors. So there's nothing left from which indemnification could be paid. Also, in terms of representations as to conditions of the properties, such as lead-based paste closures or things like that, your normal representations that are used in property disclosures, the trustee has no knowledge, not having been the one who's owned the property for whatever period of time, like the debtor was for prior to the bankruptcy case. A trustee simply inherits something in the condition that it's in, and the trustee simply lacks the knowledge to make the representations that a normal seller might otherwise make. So whenever I'm representing a Chapter 7 trustee and I'm dealing with a broker for the first time, I will alert them prior to me sending over the standard track form that you're going to see some red lines in this. And that's just simply by the fact of bankruptcy law. Another example of an interlineation would be compensation. Compensation by a broker can be expected once the property issue has been sold and closing occurred. It's typical for the broker to get paid just like everybody else gets paid at closing, whereas the standard trick form has a little bit different language in it as to when a commission is earned. In a bankruptcy case, a commission will be paid and earned at the time the property actually closes, rather than any other circumstance that is normally found in your standard form of track contract. Now, when a trustee or a debtor in possession employs a broker, it's a process. It's an easy process, and it's a process that typically the trustee or the trustee's counsel will undertake. And that involves filing a motion with the court saying the trustee, for these business reasons, wishes to employ a broker to sell, typically, real property. And as part of that process, an affidavit will be solicited from the broker disclosing any connections that broker might have to the trustee's attorney, the debtor, any of the creditors, any of the parties who are actively engaged in or who might be impacted by the bankruptcy case. It's not that if you have a connection, you're automatically disqualified. It's not the standard. Rather, it requires for connections to be disclosed, and along with any other information that might give pause as to why it would be advisable or not advisable for the trustee to hire a particular broker. That would be an extraordinarily unusual turn of events, because trustees typically either use a pool of brokers that they're used to dealing with, which is non-exclusive. It's most brokers can get their name in front of a trustee and potentially get some business if they act with diligence. Or the trustee is going to a different location, say a different city where the property is more than only practice, and they might just simply do a Google search for brokers. So it's unusual for there to be much connection, if any, between the broker and the Chapter 7 trustee, and very unusual for a broker to have connection with other parties involved in a bankruptcy case. On the back end, when you're closing the transaction, you got a contract, and then you're taking that contract to the title company. You've got a buyer. You're going to get an earnest money contract. You have to. It's not unusual for those brokers to expect there again to be interlineations in that contract by the trustee because of the fact that you've got a bankruptcy case and the trustee can only do certain things. So again, you're going to have some interlineations from that standard form of TREC contract that typically don't affect, the substance of the sale. A common example of an interlineation that I will do all the time is in the event there's a default. I will always limit the default remedy language to say that if buyer defaults, then seller's remedy is to terminate this contract, and that's it, and vice versa, so that everybody can walk away cleanly rather than set up litigation down the road. That's not the goal of most Chapter 7 cases or any bankruptcy case. It's just the goal is to sell property as soon as you can for a good price and get on down the road, not engage in litigation over things that can be avoided. So there will be interlineations.
Yeah, and I think that's an important point, Mark, because one thing that we want to talk about here is the process. Um, and the process involves the estate, number one, having to file a separate pleading with the court to hire a professional, then getting the documents that we need to be able to file the motion to sell, and then getting that order entered. So can you talk a little bit about um, how long does it typically take for a motion to sell to be approved by a bankruptcy court?
It's a great question. As you said, a motion to sell will need to be filed with the bankruptcy court. For the practical matter, whether you're a Chapter 7 trustee or a debtor in possession, um, you will need to seek court approval uh, to for approval of the sale of any type of property. That's just part of the process. And that involves filing a written motion with the court, which is the task of the trustee's attorney or the trustee, him or herself. Typically, the attorney will help with that. So what I normally tell a broker for one of my trustee clients is to tell the broker for the buyer that there's a process we have to go through, and it's going to take longer than what you normally experience in a non-bankruptcy transaction. So what will happen is that the trustee's attorney will draft a motion to sell. It's not an extensive pleading, but it has to set forth the reasons why the trustee believes the proposed sale to be in the best interests of the creditors of the bankruptcy estate. Typically, you have already got a piece of property that's been marketed, you've got the best offer, this is the most amount of money you're going to get, and you're telling the court that you're not pleading more eloquently than that, but that's what you're saying. So it takes a little bit of time to file the motion, maybe a day or two tops, depending on workload. Once that motion is filed, what I will tell most parties involved in the transaction is that it's going to be between 30 and 45 days typically for the court to have ruled on that motion and approved the sale. Or if the court has a question or issues with it or requires the trustee to present evidence as to why he or she thinks the sale is in the best interest of the creditors of the estate, they'll set a hearing, and then within a certain period of time, usually pretty quick, after that order is entered, setting the hearing will occur. So that's why I give a buffer for people 30 to 45 days. Most of the time, in bankruptcy cases, it takes closer to 30 than it does to 45. But there are certain circumstances where it might take longer. That process can be sped up in certain circumstances. If there's a reason for the court to consider things on an emergency basis or to consider things on an expedited basis. Emergency is got a really bad thing that's going to happen. You've got to get a court approval for it within a very short period of time. As long as you articulate a good reason for that, and people are willing to swear under oath for the basis of the emergency, you typically get a hearing very quickly and go to closing a lot sooner. Expedited, it means shortening your sale period, your approval period, usually from 30 days down to maybe a couple weeks or maybe 3 weeks. Regardless, motion filed, court considers the motion, enters the order approving the sale. Typically about 30 days. Then what has been my experience with title companies is that their underwriting standards require that another 14-day waiting period pass before that title company will close. That is not a universal policy. I have been able to get a title company to waive or shorten that 14-day period in unusual circumstances. But the typical pattern is that you have to wait 14 days and then close. So I will, in telling the broker or who parties involved in the sale that, well, it's 30 to 45 days for court approval. Then you got to wait another 14 days for the sale to actually, for the title company willing to close the transaction. So again, that's your typical time period for a bankruptcy sale. And most of the time, the parties involved in the bankruptcy sale have no issue with that. And there's no complaints. Sometimes people want to move faster for whatever reason, economic, any range of reasons have been presented to me over my career, and you can shorten, but there's always going to be a time delay in between. You file a motion, you get a court approval, you close. And typically I'll tell people that process can take up to 45 to 60 days in that initial 30, 45 plus 14. Long way to answer your question, but that's what I try to explain to you.
And talk a little bit about when a sale can actually close after the order approving the sale is entered.
Well, in bankruptcy court, when an order is entered, that is a final order. And what is a final order is the subject of an entirely different CLE presentation. But typically it takes 14 days. Well, the law says it takes from the date of the entry of an order till it becomes final. It's a 14-day period. And during that time period is when parties in interest who don't like what happened have the ability to potentially appeal the court's ruling. That's rare. When you have highly contested cases, though, that's an opportunity for parties to go try to appeal and get a different ruling from the court above the bankruptcy court. But that is the basis for most title companies' desire to wait at least 14 days from the date of entry of the order until they will close, because they're worried that an appeal might occur. Now, the bankruptcy code has contingencies for that as well. When you have findings by a bankruptcy court that there's a good faith purchaser, in general, there are always ifs, ands, or buts, all this process. If you're found to be a good faith purchaser and you close within that 14-day period for whatever reason, it's difficult for the parties on appeal to unwind the sales transaction. And they're arguing for money rather than the dirt that got sold.
Mark, we have a question in the chat from Scott, and he puts a scenario to you. So I'm going to say what the scenario is. A couple owns property. One spouse is in bankruptcy. Other spouse has liens. Does the court have jurisdiction to strip liens of the non-bankruptcy spouse? So Scott, we may need you to pitch in. What do you mean exactly that the other spouse has liens, like attaching to the property, or just as
it would have to. The lien in question, for it to come under the umbrage of 363F, would have to encumber the property to be sold. So, Scott, I'm presuming that's the nature of the question.
That's right.
It can, and it's not necessarily stripping the lien. It's putting the lien off of the real property, usually being real property, from the real property onto the proceeds of sale. It would be very fact intensive to your question or to your hypothetical, but that is part of the function of 363F. It is to allow something to be sold in a bankruptcy case when there is a bona fide dispute over ownership or the validity of liens against the property. Now, if you got a lien by a non-filing spouse against a piece of real property, and that lien doesn't exceed the value of the real property, well, then that's an easy sale. You've got proceeds of sale that lien applies to. But even in the situation where you've got a non-filing spouse having a lien against a Chapter 7, a debtor's property, it is possible in certain circumstances to sell that property and reserve the proceeds for final disposition of the litigation between the parties. It's 363F. One of the policy considerations behind it is to get finality, to get the argument stopped being over dirt or personal property and have that argument be over money instead. So it is possible in your situation to have that property be sold and the lien removed from the real property being sold to a third party, and that lien encumber the proceeds of sale.
So how much of this hypothetical is impacted by whether the property is joint community property as of the petition date? And Scott has one more thing, and I think it's important. Can't stress enough the need to work with the title company before the hearing
Oh,
to
yes.
get approval of the proposed order. And I think that is really important. I know uh, we have one of the realtors on today that we work with in some cases, but we always send around a copy of the motion to let people look at it before we file. So I think that that is really important.
Oh, absolutely. I agree 110%. What I will do typically when I file a motion to sell, we will have already obtained, already engaged with a title company to open escrow. And typically that title company will have already issued a title commitment so that we can take a look at what the condition of the property is, because it is certainly not uncommon for a debtor to not have disclosed certain encumbrances against a piece of property. And the debtor may have been silent on it, the title commitment won't be. So it's really important to get that title commitment. In fact, most of the time, I will have gotten a nothing further certificate or a current lien search. To me, that's the same term. From a title company, either as an informal process or as part of a formal process. So we can get a heads up as to whether or not there's some undisclosed liens or unknown liens. But once that motion is filed, typically I will have pretty soon after filing the motion, or even before, have sent a copy of my proposed sale orders, the order that would be signed by the bankruptcy court approving the sale, to the title company and said, please show this to your underwriting department. Does this pass muster for them? I've used the same form of sale approval order for a long time, so the answer is almost always yes. But yes, it is very important to have that title company engaged before you have that order entered, because if the order doesn't make provision for the problem that comes up, then you have to go back to the bankruptcy court to get that problem solved, and that means more time and more expense for the parties involved. So agree 100%. Back to the other question, Ms. Curtis, that you rose about joint community property versus any other form of community or any form of property, sole management or separate property. For when you have a married couple and one of them files for bankruptcy relief and the other doesn't, that is not an uncommon scenario. For the property in question to come into the bankruptcy estate, for the Chapter 7 trustee, the Chapter 11 trustee, 13 debtor, whatever the trustee of the debtor is, for that to be property of the bankruptcy estate and capable of being sold in the bankruptcy case, it's typically going to have to be either separate property, sole management property, separate property, sole management property of the debtor, not of the non-filing spouse. In other words, the non-filing spouse is the spouse that did not seek bankruptcy protection. Or if it's joint management community property, then it will come in as well. Now, you can dive even further into that if you've got tort-based debt for the party who has filed bankruptcy. In those circumstances, you might be able to get the non-filing spouse's sole management community property, real property, to be brought into the bankruptcy case. It's unusual for that to have occurred, but it's possible. So the nature of the property and the nature of the debts involved can be very important as to whether or not a trustee has the power to sell real property.
Well, Scott, excuse me, Mark, I was looking at Scott's message there. I think that we've gone over a lot of the basics here on selling real estate in bankruptcy. I'll open the floor for any additional questions if anyone wants to chime in. If not, I guess one thing I'd like to know for everyone on today, just maybe a final question from me is, what are the typical edits that you see requested from underwriters and different parties to real estate transactions that have led you to create the forms that you have now?
Oh, yeah, I try not to recreate the wheel as much as I can. The form of typically trustees will only give a special warranty deed. I've never in my 25-year career recommended giving a general warranty deed by a trustee. All my trustee clients only get special warranty deeds where they guarantee title by through and under. So the form of special warranty deed that I've used, I've just created over time, and I will provide that to the closer in advance of sale if I'm the one drafting the deed. And usually that form is accepted in its current form. I've not had too many alterations. The exception to that would be where the buyer is getting financing and the lender wants vendor lien language in the deed. I have an alternate form of deed where the vendor lien language is already in there, or I'll just punt and say, why don't you guys draft it instead? So that's one example of an edit. Racking my brain for more. Sometimes the underwriting company will come in and ask for special language in the form of order approving the sale, because the order issued by the bankruptcy court is different from the deed that transmits title from the seller to the buyer. That is few and far between because the form that I use for the order has again been adapted over time. And I wish I could take credit for it, but I obtained that form from people smarter than me a long time ago. So it's been worked on by a lot of smart minds and typically hits all the issues. So there we go.
All right, thank you, Mark. Scott, Vicki, Chris, do you have any questions today? If you don't feel like speaking up, you can type them in the chat. Okay, well, I'm really excited that we got to do this presentation today. Thank you so much, Mark, for your time. I will make the recording available on the Rio Grande Valley Bankruptcy Bar YouTube channel, and I'll let you all know when that is published. So,
Catherine, I'm sorry, I couldn't unmute. Is it possible for Mark to provide to us the form special warranty deed that he recommends?
Well, the form I use is the one that I use for my transactions. I'm happy to give you a copy of it. Whether or not it's recommended for your particular transaction, I think you need to go pass it by the underwriter just to be sure. But I'll be happy to pass the form of deed that I use off to Catherine, and you'll be able to get that to her.
I appreciate it. I know a form, you never use just a form. You've got to tailor it to each individual situation, but at least it provides some guidelines.
There's blank spaces where to put the name of the buyer and seller and all the other stuff, but it contains the buy through and under language that you're going to find in special warranty deeds. And another thing that I recommend, and this is part of getting approval of the form of special warranty, it's always good to get the title company to tell you which legal description to use. I have had circumstances where I've had a deed into the property from a debtor where they got title and tried to use that legal description, and the title company came back and said, well, there was a survey on this particular transaction, so we want to use that survey, or there's some other legal description that we think is better for purposes of our title insurance, and that we wanted to use that. It doesn't happen often, but it does happen. So that's another important consideration.
Thank you very much. I appreciate all the advice that you have provided to us today.
My pleasure. You have a great day.
You too.
All right. Thank you so much, Mark. Thank you, everybody, for appearing today. And I will let everyone know when this is out there. So we'll stop recording.